Good afternoon and welcome to today's presentation. We'll just allow a few minutes for everyone to get logged in. Thanks for joining us. Welcome as you're starting to join today's webinar. We will get started in a few minutes after everyone has had a chance to get logged in and join the room. If you can hear me and see the cover slide for the presentation, the NLRB in 2022, then you're in good shape. There's also a chat feature where you can type in any questions you may have during the presentation. We'll go over that more when we get started. I am Scott Horton. I will be today's presenter for the NLRB in 2022 webinar. We will get started in just a few minutes and go for basically an hour, depending on question and answer, because I will do that primarily at the end and stay on as long as there are questions. As you're joining, hopefully you can see the slide, the NLRB in 2022 new challenges for private employers on your screen. We will go through the slide presentation. Then at the end, I will make that available for you to download to keep for future reference. So that will be available. Thanks to all of you who are joining. We will get started in a couple of minutes. We're still having a good number of people filter into the room. Just for anyone who has joined in the last minute or two, as long as you can hear my voice and see the slide, the NLRB in 2022, then everything should be good to go. The chat window is available for you to either say hello or ask questions as we get into the presentation. Just a minute, I will go into that in more detail. And as I just mentioned, these slides will be made available for you at the end of the presentation. All right, we'll just wait about one more minute for anyone else to get logged in. I do want to get started pretty much on time here. My plan is to go for about an hour. We will do question and answer at the end, and I always try to stay on as long as there are questions. So if you have questions during the presentation, use the chat function to type them in. If by chance I can address them as I'm going, I will. Otherwise, most of the questions will be answered at the end. All right, there may be a couple of people still trying to log in, but I want to go ahead and get started, at least with the preliminaries. Again, my name is Scott Horton. I am the founding attorney of Horton Law PLLC, based in Orchard Park, New York, which is just outside of Buffalo. As I'll talk about in more detail in a minute, this topic is not New York specific and does pertain to many and most employers throughout the United States. So if you're logging in from somewhere outside of New York, welcome. Many of my presentations do touch on New York specific legal issues, but this one is the same nationwide. The NLRB in 2022 is your early year sort of prediction, but let's call it more of a background and what might be happening that could affect you presentation from my perspective, and not a perspective that I uniquely hold. Most employment lawyers like myself share similar perspectives. What we expect generally is that the National Labor Relations Board this year will do many things that will pose new challenges for private employers throughout the country. Just again, logistics, you should be able to hear me, see the slides, and type in the chat room. If you can do that, then you are in good shape. Ask questions whenever you have them. I will primarily answer them at the end. Just remember that if you type in questions with your name, they are not necessarily confidential. Anyone can hear them, and I cannot give you confidential legal advice in this presentation, but I can give general advice or legal information based on the questions that you ask. But if there is something that's sensitive and needs to be maintained as confidential, then you should contact me or your attorney separately outside of this presentation. With that, let's get started. To give you a quick overview of where we're going over about the next hour. Again, you'll get the slides at the end of the presentation, so you don't need to feel like you should copy down everything that's on the slides. Probably more important that you take notes on things that I say that are not on the slides, which will probably be in many cases more interesting anyway. The National Labor Relations Board has some interesting dynamics that I'm going to describe in a little bit of detail so you can kind of understand where we are, how we got here, and where we're going. That includes some mention of who the people are that are involved. It's not the Supreme Court of the United States, but for many legal purposes of interest to private employers throughout the country, it is somewhat similar to the Supreme Court. So in that sense, I think it's worth understanding a little bit who the people involved are. Once we get that background information addressed, I'm going to talk about what policy shifts we are expecting to see as early as this year and some of the specific ways that that could impact your organization. And that include, by large measure, things like workplace rules and some of your practices. And we'll spend a little bit of time talking about what it could mean for unionization, which could also affect those of you who have employees who are not currently unionized, but might decide to pursue that path in the near future. So with that, the National Labor Relations Board, again, is a federal agency. It is not part of the U.S. Department of Labor, but rather is a separate agency based in Washington. It enforces the National Labor Relations Act. The board itself is a 5-member board based in Washington, and then there are 26 regional offices scattered throughout the country that do most of the day-to-day work of receiving unfair labor practice charges and representation petitions, investigating them, adjudicating them, up to the point of, in some cases, a trial before an administrative law judge. In less common situations, the NLRB itself will go to court to get legal remedies or pursue legal remedies through federal court, but that many of the cases are processed internally, and once an administrative law judge rules on a situation, it can get appealed to the National Labor Relations Board in Washington. So most of the policy ultimately is determined based on the decisions of that board. The board decisions can be appealed then into federal courts and sometimes reach the U.S. Supreme Court. So it's not that the National Labor Relations Board is the final authority on the National Labor Relations Act, but it is the most significant force in determining policy under the National Labor Relations Act, and we'll talk in more detail about what that means. Now, just important, I want to go over the jurisdiction of the NLRB briefly because I want you to at least understand whether your organization might be subject to everything that I'm talking about today. So first of all, it is a private sector law. So private sector employers and their employees and labor organizations that represent employees in the private sector are subject to the National Labor Relations Act. That means that local, state, and federal governments generally are not subject to the National Labor Relations Act and the operations of the National Labor Relations Board. There are some situations where there's a little bit of ambiguity as to what the coverage is. For example, in New York, we have charter schools, which are kind of quasi-public, arguably private in some respects, entities. And the National Labor Relations Board has gone to lengths to try to determine whether they have jurisdiction over those charter schools, but I would say it's not by any means a settled issue. There are specific exclusions for certain agricultural workers, people actually growing and picking the crops in the field, not those who are canning the produce after the fact. But so that is a possible exception. And then the main exception among private sector employers is where the Railway Labor Act would have applicability, and that means generally interstate railroads and airlines in the country. If you are a private employer that's not subject to one of those exclusions, then the National Labor Relations Board can assert jurisdiction as long as your business affects commerce. The standard for affecting commerce is pretty broad, probably broad enough to cover all of you without any question. However, the NLRB doesn't always exercise its full jurisdiction, so it does view some businesses as having operations that are too small to be, I guess, worth their trouble, or maybe the better way of looking at it is too small to have to be worried about dealing with the National Labor Relations Act. However, those standards are pretty small in most cases. They vary by industry, and they typically are based on total annual revenues ranging, depending on industry, from $50,000 to $1 million. So if you're a private employer with over $1 million in annual revenues, you're almost certainly going to be subject to the NLRB's jurisdiction. Really, the $1 million threshold only applies to a couple limited categories of cultural and educational centers, private colleges and universities, and art museums and symphony orchestras being the main situation there. For retail and other non-retail types of traditional businesses, the thresholds are much lower. 500,000 for retail businesses of most kinds, with a few special carve-outs that I don't want to spend too much time on. Most non-retail businesses, the threshold is only $50,000. Again, there are a couple other special categories, but by and large, most of you are with organizations that are going to be covered. If you're not covered by the National Labor Relations Board, it is possible that a state law would cover you. Many, but not all states have similar laws covering public sector employers. And in New York and some other places, there are some backup laws that cover private sector employers that happen to fall outside of the NLRB's jurisdiction. Okay, so assuming you're in the right place and I didn't just carve you out entirely, then the most important portion of the National Labor Relations Act for us to be familiar with for what we're talking about today is Section 7 of that law. For the most part, I'm not going to get really detailed into statutory or case law discussions. This is, certainly a presentation suitable for attorneys, but most of you are not attorneys, and I'm not going to become a law school professor if I can help it here. But we do need to understand that there's something called Section 7 because that's pretty commonly thrown about as what the National Labor Relations Act does to protect employees. Section 7 gives employees the right to self-organization, to form, join, or assist labor unions. So this is the law that enables workers to decide that they want to be represented by a union and then have that union bargain with their employer for the terms and conditions of their employment, which is the next component here, bargaining collectively through representatives of the employee's own choosing. It also, separate and apart from the pure bargaining and organizing scenario, gives employees the right to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And this concerted activities for mutual aid or protection is what ends up creating a large panoply of potential legal hurdles, obstacles, restrictions, wherever you might want to call it, in workplaces, whether they have labor unions around or not. So a lot of what we're going to be talking about is how this concerted activity and mutual aid and protection right could affect you, whether or not you have any employees in unions. And finally, the Section 7 rights include refraining from any and all such activities. Now, that's a little bit complicated. Whether you're in a right to work state or not in a right to work state might affect employees' ability to support or not support labor unions or to be members of labor unions to some extent or another. But most of those details are not what we're worried about today, but it is important to understand that the law theoretically at least gives employees the right not to engage in all the activities that it gives them the right to engage in. Just real quickly, I want to throw out one quick question just to get to poll the audience to see whether your company does have employees represented by unions. So I'm going to throw that up. Hopefully it pops up for you and you can just click whether your company has unions or not. Okay, so the substantial majority of you are in companies that don't have unions, which is perfectly fine, and that's what I expected. Less than or about 10% say you do have unions, with 85 to 90% saying no. And again, that's not unusual. That's pretty much consistent with the overall private sector workforce across the United States these days. Anyway, some parts of the country obviously have higher unionization than others. There are some interesting developments that I'll comment on as we go forward, but certainly most of what we're building up to is addressing a lot of ways that this Section 7 under the current National Labor Relations Board could have serious implications for your workplace, even if there is no union. Okay, so just for a little bit of more color on this before we get into all the issues, the current members of the National Labor Relations Board are going to be listed on the following slides. I'm not going to spend too much time on all of them, but I'll just kind of show you how this works to show you how we are where we are. And these are in order of their length of current service on the board. So Marvin Kaplan, who may well still be the youngest member of the National Labor Relations Board, has been on the longest. He was appointed by President Trump back in 2000 2017. He is a Republican, and his current term expires in 2025. They're 5-year terms, so he's been reappointed once already. His former positions were mostly in federal government, some council positions in Washington for administrations and the House of Representatives. Obviously, he is a Republican, so he was connected to Republican House members and appointments. In that regard, he briefly was in private practice before beginning his government service. Why I'm giving you all this information will become more obvious in a minute, but the one thing to note as I bring up the next member, John Ring, who's also a Republican, is that the historical practice, although it's not actually required by law, is that of the 5 members of the National Labor Relations Board, at any given time, 3 of them are representatives from one party and 2 of them are representatives from the other party, meaning that once the sitting president, has the opportunity to appoint enough members, his party then takes control of the National Labor Relations Board. The members do have 5-year terms, and they can't, or at least have never been removed short of those terms by the president. So when a new president comes in, they don't just automatically pick 5 new members or replace whoever they want. They have to wait until the existing terms expire, and then they can nominate someone, potentially changing the party affiliation of a given seat at that point in time. Anyway, John Ring was the chair of the National Labor Relations Board before Biden became president. He couldn't appoint somebody new immediately, but he can change the chair, which he did immediately in 2021. But so Ring was the chair before that, and before joining the board in 2018, he was in private practice representing employers in labor matters. Now we get to the Democrats on the board. The current board chair, Lauren McFerrin, was most recently appointed in 2020. Again, recognizing that was a Trump appointment, but there were already 3 Republican seats filled at that point in time. So she was appointed to fill essentially one of the minority Democratic seats at that time. Her term now expires in 2024, so you'll notice that these seats are not always filled at the beginning of the 5-year term for various political reasons. So sometimes, and you'll see an example in a minute, someone is appointed for a very short period of time, and then it remains to be seen whether they can get reappointed. Lauren McFerrin is a former counsel for Senate Democrats, and before that was in private practice representing labor unions. Gwen Wilcox was recently appointed in August. Her term expires, however, in 2023. It took some time to fill her seat, and the seats have fixed expiration dates. So you don't get 5 years from the date you are appointed. She also is a Democrat, and her former position was in private practice representing labor unions. In connection with that, she was the associate general counsel of a very large union, 1199 SEIU, United Healthcare Workers East. And finally, the 5th member was appointed in September, also a Democrat. His former positions also representing unions, including the Major League Baseball Players Association. So as you can see, if you've been following along, the Democrats come from that party and generally have represented unions in their past positions. The Republicans come from the side of representing employers. And what that means is when the majority of the board shifts from Republicans to Democrats, we end up seeing shifts in policy under the National Labor Relations Act. But again, it doesn't happen automatically when the president takes over because these seats have staggered 5-year terms. One other very important person with the National Labor Relations Board is the General Counsel, currently Jennifer Abruzzo. She's a Democrat. She was appointed by President Biden. The interesting thing about this position is it is one that has a 4-year term, actually from appointment. And when Biden became president, he immediately fired the previous general counsel, who was a Republican appointee of President Trump. That broke with tradition. Historically, the general counsel had been allowed to finish out his or her, almost always his before now, term. And the aftermath of that was not immediate because the board was still Republican majority until late last year. But the general counsel position has a very important role because they control what charges that are brought to them get prosecuted and the manner in which they get prosecuted, which positions the NLRB is going to take in prosecuting cases up to the board, and therefore the views of the general counsel ultimately end up dictating policy, especially whereas we now have the case here, the general counsel's affiliation and background. Ms. Abruzzo was also attorney for the Communication Workers of America, so another union. Now we start to see alignment, and that's going to come out in the decisions of the board. Okay.
That's what I found.
All right. So the one other thing I want to mention is the current Congress has made some effort to pass the ProAct, which is a very pro-labor piece of legislation that would dramatically amend the National Labor Relations Act in many ways to increase worker protections and, frankly, to increase the penalties on employers for violating the National Labor Relations Act, including the new protections. Make it a lot easier in some ways for workers to unionize, and clearly is supported by the president, who noted in his American Jobs Plan last year, it has never been more important for us to invest in strengthening our infrastructure and competitiveness and creating the good paying union jobs of the future. The House of Representatives has already passed this legislation. However, it's unlikely to pass in the Senate. Many of you know that the Senate is currently split 50-50 between Democrats and Republicans, with the vice president potentially being able to cast a deciding vote. But because of the filibuster rules, it is very hard to get controversial legislation up to vote. Certainly, the Republicans are not going to allow the ProAct to come up for vote as long as the filibuster remains in place, which looks like will be the case indefinitely at this point. So it's not that we expect the ProAct to become law very soon, but I pointed out now to sort of foreshadow that a lot of the positions we're expecting the general counsel to take and potentially the board to enact in their cases going forward would be to get as close as possible to the ProAct without actually amending the statute. So real quick, I just want to stop and point out that obviously there's political talk in this presentation and mentions of what one party thinks, and it's not that I'm trying to take sides and that in the general sense or disparage either viewpoint, and whether unions are good or bad is not the point of this. It's just to really get at the clear fact that federal labor policy under the National Labor Relations Act, as adjudicated by the National Labor Relations Board, really depends on which party is in control, and the impact of that on any given workplace requirement is very telling. So I think one way to think of this is if you think of a pendulum that kind of goes back and forth, that's pretty much what happens when the party shifts on these labor issues. And I think it is probably fair to say that the pendulum is getting faster and the amplitude is getting higher, if that's the right term. In other words, the pendulum is swinging further back and forth in each direction as time goes on. So historically, there might have been a little shift back and forth when the party in control changed over, but in the last 10 or 20 years, the shifts have become even more dramatic. And I think there's every reason to believe that will continue to be the case, that what their current um, pro labor views at the National Labor Relations Board will do is push further than even their predecessors under the last Democratic president. So, what happened when that general counsel was fired at the beginning of last year? Well, actually, there was a um, acting general counsel appointed for a short period of time before Jennifer Abruzzo was nominated and appointed by the Senate, or approved by the Senate anyway. The acting general counsel immediately rescinded a bunch of guidance memos from the previous Trump appointed general counsel and also issued one of his own. Peter Sung Orr was the acting general counsel, now deputy general counsel. He issued one guidance memo, which he called Effectuation of the National Labor Relations Act through vigorous enforcement of the mutual aid or protection and inherently concerted doctrines. So I mentioned that issue from Section 7 before. Clearly, as soon as he got a chance, the acting general counsel announced that he was going to be aggressive in expanding those rights for employees. The now duly appointed general counsel has issued several guidance memos of her own. Basically, these are memos that the general counsel writes to the regional offices and tells them how they're going to do their job now going forward. But they become public, they're publicized because they frankly have to be anyway. So we can see what the general counsel is thinking and how they want to adjudicate the act. The current general counsel has used the term of reviewing doctrinal shifts in board law. So I'm going to use that term here, doctrinal shifts. She issued a memo in August where she listed over 50 categories of cases that had to be sent from the regional offices to Washington for her office to review in their office of advice to determine what the agency's approach was going to be in these cases. And basically, what this means is she's saying, I don't agree, or I probably don't agree with the most recent decisions from the Republican majority board on this issue. So I'm going to take a different view and find that something violated the National Labor Relations Act, even though they didn't. And I'm going to push it to the board, which I now think is going to be friendly to my views. Again, that I don't think anybody would really dispute that. They might couch it in different words, but clearly that's what's going on. There are actually 67 categories of cases that she said she wanted to review, but 15 of those or so were kind of cases that are always reviewed in Washington, but the rest are just ones where she's pretty literally saying, I don't agree with the current precedents from the pro-employer boards, so I'm going to try to overturn them. So what are these doctrinal shifts? So this is where we really start to get into how does this all matter to you. I just wanted to give you the background of how and why we got where we are. So it is very extensive and in some cases very nuanced and detailed and issues that not everybody is ever going to have any reason to deal with. So I've only broken it down to some of the ones that are going to be most broadly impactful, starting with employer handbook rules. Under the Obama era National Labor Relations Board, we had this interesting confluence of the emergence of social media and therefore social media policies in the workplace, and a board that was looking to find ways that they could more emphatically apply the National Labor Relations Act to protect employees. So everybody wrote these social media policies, and then the National Labor Relations Board somehow got their hands on them and started pointing out aspects in them that they said, you can't tell your employees they can't do this or they have to do this other thing because that violates their rights under the National Labor Relations Act. So from there, we started seeing a significant uptick in charges complaining about workplace policies and rules, and many different categories of rules were challenged. I'm going to get to those in more detail on another slide. Of course, the backstory on that so far has been Obama left office, Trump came in, eventually the Republicans became the majority on the board, and then they issued decisions that overturned the standards that the Obama board had applied and created a whole host of guidance suggesting that, well, these rules are actually okay. So that is one thing where almost all of you should be aware that there's likely to be shifts, and it could have implications for what your rules are, especially if there are rules that have been put in place or modified sometime since the Obama administration, or otherwise were in place before the Obama administration and were never reviewed by counsel to see whether they ran afoul of what the board at that point in time said was problematic. Another issue of a lot of discussion in the past few years and over the past decade at the National Labor Relations Board level has to do with confidentiality provisions. We see a lot of scrutiny of confidentiality provisions related to sexual harassment and other forms of workplace discrimination and settlement agreements and that sort of thing. And the National Labor Relations Board, based on information from the General Counsel, is likely to take fairly aggressive positions in saying that even asking employees to agree to a confidentiality provision in something like a separation agreement may violate their rights to engage in concerted activity for their mutual aid and protection, because it would limit their ability to talk to their fellow coworkers about possible problems in the workplace. The other confidentiality issue that was a big surprise, again, maybe a decade ago at this point, was the board coming out and saying that employers don't have a general right to require employees to maintain confidentiality during workplace investigations because of their Section 7 rights, again, to discuss those matters with their fellow employees. More generally, and you can pretty much assume all of these issues, again, that the board in the last few years under the Trump administration came out and issued decisions that went back and gave employers more leeway to do these types of things. So more generally, there are a lot of efforts to review activities that might be considered protected concerted activity. The acting general counsel in his memorandum, for example, talked about employees' political and social justice advocacy, where the subject matter of that might have a nexus to their employees' to their interest as employees. So, for example, taking action against an employee somehow related to their participation in a protest over minimum wage issues, even if they're not, particularly attacking your company, could involve concerted activity and violate their Section 7 rights. So expect some interesting prosecutorial approaches from the general counsel's office on that. Remedies and settlement agreements. Now, here we're talking about settlement agreements where you've actually had a case filed against your company at the National Labor Relations Board and you are trying to settle the case. For example, let's say somebody complains that one of your employee handbook rules is inappropriate because it prevents employees from discussing something that they should be able to discuss. Well, now the board wants to pursue any possible remedy that they can think of that might theoretically make whole whoever the employee or union that was aggrieved. To be absolutely frank, what they're trying to do is make remedies punitive and turn them into penalties, even though the National Labor Relations Act has never been applied to permit punitive penalties. I mean, for example, there's a couple of memos on this that talk about as going as far as if an employee was terminated because of some protected activity, that the remedy should include compensation for damages caused to the employee's credit rating as a result of the unlawful firing. In other words, they missed payment because they didn't have a job. So now the employer has to somehow make them whole for the impact on their credit rating. I mean, the long and short of this is, if nothing else, it's going to be much harder to settle or otherwise resolve a case with the National Labor Relations Board. Reason to believe that that's by design, that they're not necessarily as interested as they would have been in the past to resolve cases. But again, it is a real sea change in that regard for those who actually have cases against them. There are important issues regarding union access to the employer's property. One example of this has to do with employee use of company email accounts. There was a case a while back now, probably more than 10 years ago, called Purple Communications. That was the name of the company involved. And the board said that employers cannot prohibit employees from using company email accounts to engage in their Section 7 protected activities. So in other words, if employees want to email other employees about whether they should form a union, they have the right to do so on company provided email accounts. You don't have to provide an email account in the first place, but if you have, then you have to allow them to have that type of exchange. Again, the current board has backed off on that. Again, that will change almost certainly under the new board. If nothing else, it's frustrating that these policies and rights and restrictions bounce back and forth with the change in the administration in Washington, but that is genuinely the reality. Otherwise, access to employer property in some cases can mean literally the board saying that the union can come on to your property to speak to employees under different circumstances. For the most part, those circumstances have been relatively limited historically, but there are different ways that the board is looking to push that further now. For example, possibly compelling employers to let unions come in to speak to employee groups, if not on company time, at least in company facilities where there's easy access to the employees. Union dues, there's a couple different categories here involved, but basically some ideas involving whether the company has to continue to deduct union dues after the collective bargaining agreement has expired, and some other procedural issues, but the idea being that the shifts would help unions continue to collect dues in situations where they might currently not be able to. Employee versus independent contractor status is going to get a renewed look. This is something that is looked at in a whole host of labor and employment contexts. Unfortunately, there's not one overarching standard. Every law has its own view, so there has to be a view under the National Labor Relations Act. But the idea here being that the general counsel likely thinks that more individuals should be classified as employees rather than independent contractors, because it's that classification as an employee that entitles someone to protections under the National Labor Relations Act. Independent contractors do not have those rights. One kind of interesting thing that came out from the new general counsel was a memo that was entirely related to student athletes, taking very clearly the position that athletes who are somehow compensated, even if by room and board and tuition, from a private university, are employees of the university, at least for purposes of the National Labor Relations Act, which means they have the right to form unions if they choose to do so. And moreover, the general counsel directly stated that merely referring to these individuals as student athletes is a violation of the National Labor Relations Act, because it suggests that they are students and therefore not employees. So that is something we haven't seen attacked before, and maybe not yet, but she has announced that that is her intention. Remembering that whatever the general counsel says is her policy view does not make it the National Labor Relations policy view until she actually takes a case that gets upheld by the National Labor Relations Board. She's also indicated a greater scope of jurisdiction over religious institutions. Private religious institutions are potentially subject to the National Labor Relations Act and the board proceedings, but there have been some historical carve outs, especially for employees who are involved directly in the religious mission. So, for example, teachers who teach religion in religious schools are more likely to be excluded from coverage than would be maintenance or custodial workers in organizations that have religious missions, because their work is not directly religious. And the board therefore finds less potential First Amendment risks of weighing in. But again, the general counsel thinks that maybe she can push the board further to take on more religious institutions under their jurisdiction. Another potentially critical issue, if you happen to get to this point, is the matter of replacing striking workers. So right now, if employees go on strike, and assuming there's not some other problem in the way they do it, employers can permanently replace the striking workers, bring in replacements, and not have to kick them out just when the strike stops. They just may have to offer the position to the people who went on strike if the replacements then leave. The general counsel does not agree with that policy as well, even though it's very long standing under the National Labor Relations Act. So again, these are just among the 50 or more categories of cases that she sort of indicated she wants to review and potentially seek a change. So that's sort of where the general counsel stands from her prosecutorial function, what things she wants to try to tackle. Let's turn a little bit to the National Labor Relations Board itself. What are they doing with their new majority? They have engaged in a little bit of rulemaking. So they primarily make policy by hearing cases like courts would, but they also have some rulemaking authority and have proposed a rule, or at least proposed that they would like to consider new rules on virtual hearings and the joint employer standard. Joint employer standard has been a very hot topic in the past few years or decade, including under the National Labor Relations Act. This, for example, it relates to whether McDonald's corporate can be sued for violations of individual McDonald's store franchises. And the idea here being that the new board majority is likely to go back to a standard of joint employers that is more likely to result in any two companies being found to be joint employers of the same employees, which in one sense means there may be deeper pocket that can be pursued as the violator of the act, or in other senses, just could require more than one entity to be responsible for protecting the rights of certain employees. The virtual hearing thing is kind of minimal. It's basically the idea that the board has to have hearings in some of these cases that are brought before them. And when I say the board there, I mean not just the board in Washington, but primarily the regional offices throughout the country. Obviously, under COVID, like everybody else, they went virtual in a lot of respects. So they're reviewing whether they should change their rules to allow virtual hearings in some cases as a general matter. It's probably a mechanism of enabling more hearings to be held, and probably relates to the possibility of fewer settlements because of how the general counsel is pursuing settlement agreements. But for the most part, it's not that surprising in 2022 based on what we've experienced the past couple of years. Election procedures, this new majority hasn't done anything with that yet, but the last two administrations have both seen the board change their election rules. The Obama board changing them to make elections faster and generally considered to be more union friendly than the Trump era board changing the rules in certain ways to go back to previous standards that slowed the process down a little, which critics attack as being more favorable to employers because it gives them more time to convince their employees not to form a union. So there's a little bit to be gleaned from that. The bigger topic or the bigger category of direction from the National Labor Relations Board so far, because they haven't issued many new foundational cases, is that in many existing cases, they've asked the public for briefs. So they've essentially solicited public opinion, which of course really means the opinion of unions and significant business interests and labor lawyers on both sides of the fence, as to how they should rule on various cases currently presented before them. The clear intent behind this is they want to change back from whatever the Trump era Republican majority board has said the standard is to something that is more labor union or employee friendly. I don't think anybody doubts that that's what's going on. Obviously, they couch it differently than that in writing. But some of the specific issues where they actually have requested briefing of this nature relate to whether employees have certain rights to wear union insignias like buttons or patches on their uniforms at work, the scope of damages and remedies for unlawful layoffs and terminations. So this relates back to what I was saying, that general counsel is looking for a broad array of at least more extensive make-whole remedies and, arguably more punitive damages against companies. Cases involving determining the appropriate bargaining unit. So when an employer or when a union is trying to organize employees within an employer, how big is the bargaining unit? And there are cases in that regard historically that make it easier or harder for a union to pick and choose the employees they want voting, for example, or who they want to be in a bargaining unit at the end of the day. Again, the idea here being we would expect this to be a shift to a standard that is more favorable to unions. Independent contractor, I mentioned with the general counsel's initiatives. The board has opened that issue for consideration as well. Mandatory arbitration clauses. The board doesn't like those on the theory that it might interfere with someone's ability to form a class action and file a lawsuit, or even just to file with the board in the first place. So again, these are specific issues that aren't going to affect most of you on a day-to-day basis, but just mentioning them in case they are important in your situation. But again, the most broadly impactful relate to work rules and Section 7 rights. So the board has expressed that they want to review, they have expressed that they want to review, but they do it by way of saying, should we review the standards of the most recent case by the Trump board, which is a case involving Boeing. So under Boeing and some other cases, the Republican majority board under President Trump held that all of these were generally lawful work rules, and that there'd be sort of a heightened standard for a union or an employee to say that they violated the act. At the top of the list, and I had a question on this already, is civility rules. So the Obama administration started saying that you can't have rules that say employees must be respectful at all times, for example, because they said that suggests that they don't have the right to take certain positions or argue certain issues that they might want to argue in pursuant of their Section 7 rights to try to improve their work conditions. So right now, civility rules are presumptively lawful, but that could easily change under the current board. Other current rules that are okay involve no photography or recording in the workplace. Again, I don't want to waste the time to say it, but all these rules that I'm saying are okay. There's reason to believe that the current board would question their validity and potentially strike the rules or say that they violate the act. Prohibitions of insubordination, non-cooperation, and conduct negatively affecting operations, disruptive behavior rules, protections of confidential, proprietary, and customer information. It's not to say that you can not have any sort of rule that protects confidential, proprietary, and customer information. You just have to be more careful how you write it under the current board, because they're going to parse it more closely and try to find a way that they can say it chills an employee's exercise of their Section 7 rights, or arguably deters them from doing something that they might have the right to do. And keep in mind, sometimes these cases come up because someone has been disciplined for violating a rule that the board then looks at whether the rule is lawful itself. But what was happening, especially under the Obama board, was companies were being literally brought up on charges just because they had the rule. Merely having the rule itself could be a violation of the National Labor Relations Act. Not that everybody's running around filing unfair labor practice charges with the National Labor Relations Board just because of a rule their company has. Where a lot of these cases came up was where a union was either trying to organize a workplace and using these unfair labor practice charges as fodder to show employees that their company wasn't doing the right thing, or a situation where the union was already involved for whatever reason, interested in what the policies were. So, prohibitions of defamation or misrepresentation. There were literally cases that said that prohibiting defamation by employees is not permissible. I mean, that goes a little far. Defamation is, illegal act, but because it's illegal under state law, the National Labor Relations Board said the Section 7 federal right might trump even someone's protections from defamation as long as it was sufficiently in pursuit of work condition improvements, for example. Limits on use of employer logos and intellectual property. Employees generally have some right to use employer logos if, for example, they're putting them on a picket sign that's otherwise lawful picketing and, trying to point out who their employer is. Not to say they could take the Ford logo and make their own car and sell it from the union with the Ford logo on it, but there would be some use there. So where that line is in question. Restrictions on who speaks on behalf of the company. A lot of companies have policies that say if you're contacted by the media, then refer the inquiry to a certain person. The fear there was that it would prohibit employees from speaking to the media on matters of employee interest, and other things like bans on disloyalty, nepotism, and self-enrichment. Just so a whole host of work rules that are currently under established law, generally considered lawful, could at any moment be challenged by the general counsel and then eventually might be deemed to violate the act by the National Labor Relations Board. Unfortunately, putting companies in a bad position. If you have these rules now, do you have to rush out and change them? I mean, it's really not an easy call. You can, if you make them safer or more conservative under the potential view of the new National Labor Relations Board. That's okay, but we don't really know where they're going to draw the lines yet. And, technically at this point, you are not violating the existing law. You're just violating what we think, or you might just be violating what we think the law might be once it gets re-adjudicated for the umpteenth time based on who is currently sitting in Washington. Just briefly on union organizing, not all of you are going to deal with union organizing, but then again, Starbucks for a long time didn't know they were going to be dealing with union organizing the way they are now. I mentioned that because we've just had the first Starbucks locations become represented by unions here in the Buffalo area, and many more in Western New York and other parts of the country are now trying to organize. But the election rules, again, will probably change, making it theoretically easier for unions to get in. There's something called card check recognition, which is something that the ProAct would implement by law, but the general counsel's memo kind of suggests that she might try to go there even without a change in the law. Normally, an employer has the right to say, we're not going to recognize the union unless we have an election by the National Labor Relations Board where the employees vote to be represented by the union. But unions can get cards signed by majority of employees, take them to their employer and say, here, based on these cards, we want you to recognize us as the union representing your employees, and in some cases, it would be okay if employers did that, or at least it wouldn't be illegal. Um, but now the general counsel has suggested that she would review what happens if the union brings a majority of the employee's card to the employer and they can't provide a good faith reason for doubting that the union has majority support. So hypothetically, if you had 10 employees and the union brings you 9 cards and you have to acknowledge that they're all signed by the 9 people that work for you, that clearly should be in a bargaining unit if there were a bargaining unit. It seems like the general counsel might be saying at that point, if you refuse to recognize the union, you have to have some good faith reason to dispute the employee's support. Where historically you've had an absolute right. I mean, barring you engaging in some really shady behavior, to just say we want an election. So we'll have to see where that goes. Expanded remedies for failure to bargain. Some really interesting things have been proposed here, including the board setting a schedule for when you have to bargain if for some reason they found that you weren't bargaining with your union appropriately. They might require you to meet on Tuesdays and Thursdays from 3 to 5 p.m. And then if you don't, that's a separate violation of the National Labor Relations Act, things that historically have not been done. Unfair labor practices. This is only the point of all these other things that I've talked about. If the board thinks you've done it wrong and it's somehow in connection with a union organizing campaign, then that can be a problem. It could result in overturning elections or changing the outcomes of other cases, so could have trickle down effects. A couple other things that are involved: unilateral changes. The Trump era board was more accepting of companies making certain changes, especially after contract expiration. Like I mentioned, stopping deducting union dues, but there are other examples. Obviously, the new board is likely to go the other way. Strikes and picketing. Again, the idea is that the current board would be more protective of employees and less concerned about protecting employers and things like right to access their premises or to keep from being unduly interfered with in their operations. All right, finally, just a couple minutes over our hour here, but if there are any questions, go ahead and start putting them in. I'm going to put up the link to the slides in just a moment. The last point I want to make, though, is very recently there have been some new initiatives announced from Washington, one being that the National Labor Relations Board, the United States Department of Labor, and the EEOC have announced a joint initiative to protect workers against retaliation. And then very recently, I think in the past week, the Department of Labor and National Labor Relations Board signed a partnership agreement to enhance information sharing, enforcement, training, and outreach. So these are just new initiatives showing that different agencies at the federal government that have jurisdiction over various employment laws around the country are going to be working together at a greater level than they had in the past, meaning they'll share information, potentially meaning that one agency will point out to another where they think something is being done in violation of the law. So just something else to be aware of that's connected to the National Labor Relations Board. Again, not surprising in a Democratic administration. For better or worse, they just tend to be more labor and employee friendly than Republican administrations. So finally, I'm gonna go ahead and start posting the links to the slides and get any questions in if you have them. But you can follow Horton Law on LinkedIn. That's where we post our updates first. There, we have a blog that gets updated fairly often, but sometimes things go on LinkedIn where it either doesn't warrant a full blog article, or it's just faster to get information out there on LinkedIn. So as some of these issues and cases get decided, and we will write them up and point them out, you may want to be following us on LinkedIn to get that. Okay, so hopefully now or in the next couple seconds, you will get a link to the slides. Welcome questions. Again, if there's anything that needs to be kept confidential, you can contact me uh, offline. At the moment, I'm not seeing any questions. So if you have a question that you thought you asked, please type it in. If you don't have any questions and you're all set, then thanks for joining us. So I know there was one or two questions that came in that I answered during the presentation, but I will stay on for another moment or two at least to make sure that anyone else who has a question has a chance to get it in. So as of now, I'm not seeing any questions. I'll just summarize again by saying, it's just a lot to be on the lookout for. Unfortunately, with those handbook policies, you may be kind of in a state of limbo, especially if you're reviewing your policies anyway. If nothing else, I guess I just caution that before you act on one of those policies in a way that might somehow touch on one of these issues that I've raised that you can be aware of, you should probably get legal advice. You don't want to terminate an employee for violating a policy and then have it go to the National Labor Relations Board, especially with the new penalties that the General Counsel seems to be looking to pursue. Yeah, I think this is a question that's just come in. Do we have to change the employee handbook now or later? I mean, there's really no clear answer to that. It obviously depends on what your policies are, but it can also depend on what your risk of exposure to an unfair labor practice charges, which might depend on whether you currently have a union involved. It doesn't require a union to file a charge with the National Labor Relations Board. Anybody could do it, but in many cases, if there is a union involved, they're going to be more likely to scrutinize the policies. But if, again, an employee were to look in your policy and go to the National Labor Relations Board, they could do that. And then the board, whether they've already announced any change or not, can just say, no, we think your policy violates Section 7 of the National Labor Relations Act, and then tell you basically either you change it and do all these other things we want you to do, or we're going to prosecute you and then make you do all these things that we want you to do. Um, the backdrop on all this is the National Labor Relations Board isn't the end all and be all. Technically, you could still go to the Supreme Court, and the Supreme Court probably has a different view than the National Labor Relations Board on some of these issues, but they're not going to take most of these cases. But more importantly, by the time you get to the Supreme Court, you're talking several years down the road, exorbitant amount of time and money and legal expense, and probably not the case you're going to take over a simple handbook policy in most cases. Yeah, so again, I can't tell you generally what to do with the employee handbooks other than if you're reviewing these, you flag the issues and say, this is where the law currently is. This is where I think it's going to be sometime in the next 6 months, year and a half. I'm not really sure. What's your risk tolerance? There's as of today, the black letter law is still the Boeing decision and related decisions from the Trump era board, but that doesn't mean that you can rely on that and avoid being found to violate the National Labor Relations Act. So those are good questions. Any more before I wrap up? I'll give another 30 seconds or so. If you have something, type it in. Okay, well, I don't see any more questions in, but those were good. And hopefully, this was helpful information to all of you, at least so you kind of get an idea of what to be looking for and how it could affect you, even if you've never dealt with the National Labor Relations Board before, or think of it just as the union law or agency. There is more to it, there is significant impact on a whole host of private sector workplace issues. And hopefully, this will help you be aware of those a little more and know what might be coming, even though it, might not make your job easier. For that, thanks again, and we will see you next time.